Welcome back everybody to the Law of Tort. In this video we are going to move on away from looking at negligence and the duty of care, and we're going to start to talk about the concept of the breach of said duty of care. Now this has been a very long series of videos so far already, just looking at negligence, and we've only spent all of our time so far talking about the various different concepts and relationships to the duty of care and the subsidiary issues relating to different types of harm, so psychiatric harm and pure economic loss. This lesson and the next few lessons is going to be covering the next major topic, which is of course the concept of the breach of the duty of care and the standard of care by which a breach has to be shown to have been determinate. We will then go on to talking about the fact that we have to then have causation. We have to have causation in fact, and we also have to have causation in law. We'll look at what these two things mean in the next few lessons after we have covered the breach of duty. So, like I said, we're moving away from the subsidiary issues which pertain to the law of negligence. We obviously talk about the concept of psychiatric injury as a type of damage which can be attributable in negligence cases. Some of which are psychiatric injury, which are essentially consequential onto the damage that is physical injury or some kind of other kind of injury. And then there is also this concept of pure psychiatric harm. The idea that there is not actually a physical injury which takes place, but that there is some traumatic event to which affects an individual, which affects a claimant in only psychiatric harm, in a recognized psychiatric condition. We then spoke about the difference between pure and consequential economic loss. Economic loss, which is consequential on some kind of tangible and real damage that is caused to a claimant, is valid. So, for example, if you were in a workplace accident, the result of which caused you to have a physical injury, and the result of which causes you to have time off work at a lower rate of pay, maybe you only get sick pay, then that loss of revenue would represent consequential economic loss. But then we also noted that there is no claim for something known as pure economic loss, whereas the result of negligence, there is some kind of loss that is taken, and that loss is only economic in nature. It is not attached to any sort of physical damage or damage to property or psychiatric injury, etc., etc. We then looked finally at one of the major exceptions to this rule of pure economic loss, which is through the concept of negligent misstatement and the Hedley-Byrne and Heller principle as established and then re-established in subsequent case laws. So that's what the last few lessons were covering. This lesson is going to talk, like I said, about the next major hurdle in the establishment of a negligence case. This being trying to establish that there not only was there a duty of care, but that the actions of the defendant rose to the level of breaching that duty of care. Remember then that the negligence equation is as follows. There has to be a duty of care plus a breach of duty of care plus the causation of all of those actions to the damage that was caused by the claimant to the defendant. This then results in negligence. This next series of lessons is going to be talking about what is highlighted in red, the idea of there being a breach of a duty of care. So essentially, once it has been established that the defendant in question has a duty to take care to the claimant in the particular circumstance, it must then be shown that their actions or their lack of actions went and went to the level of breaching this duty of care. Okay, so that the standard was breached such that the damage was caused, which would then have been the result of this negligent action on the part of the defendant. The main consideration that we have to take into account when we think about what and how we can show a breach of a duty of care is to talk about the standard which is to be expected in the particular circumstances, as well as the extent to which the claimants had acted outside of this standard. So there will be, and we will see and show that there exists a standard of care, a standard by which every single person who has a duty of care has to essentially meet that standard. You have to go up to that standard at the very, very least. And for those of you who have gone below that standard, who have not managed to reach the standard of care, you have therefore breached that duty of care, and the resulting damage that is caused to a claimant, if we can show causation, would therefore result in a successful negligence case. So this is known as the standard of care, and the standard of care is something that we're going to spend a lot of time exploring in this series of lessons. It refers to, like I've mentioned, the appropriate level of care which is to be expected of the defendant. Okay, the standard of care does not imply that defendants have to go above and beyond what is reasonably expected to ensure that there is no harm that is done to a claimant, but they have to at least have done the bare minimum. The bare minimum being this line, this standard of care. If there is a breach of duty, then this breach must be below the ordinary standard which is expected. So the only way in which you can show a breach of a duty of care is if you can show that they have fallen below this standard in their actions or their omissions, which leads to the damage in question. If the defendant is acting in accordance with the ordinary standard of care and the claimant is still injured, then it is held that it cannot be the result of the defendant's breach of duty for them to have been injured, and therefore no negligence claim can happen. Remember, negligence is there being a duty of care to a claimant, and that this duty of care is breached by the actions or the omissions of the defendant. And so in order to really show the breach element of a duty of care, of negligence in general, they have to fall below this ordinary standard. So in the previous lesson, what we did was talk about the breach of a duty of care. We introduced the subject of breach, and we noted that this was the next major hurdle or any claimant who wishes to bring a successful claim of negligence against a defendant. We also then finished by thinking about this idea that the breach of duty of care is one that is measured on the basis of something known as the standard of care. Now in this lesson, we are going to talk about the standard of care in more detail, and we're going to essentially define what the standard of care is, and then look at some of the basic case law which establishes how the standard of care is applied. So, the standard of care, as we noted in the previous lesson, is the benchmark for what is expected of an individual who has a duty of care to act in a particular instance and to adhere to. So, in circumstances where there is an individual or as an organisation, some kind of defendant who is shown to have had a duty of care to a claimant, they have to act with that duty of care to a standard, the benchmark, which is essentially required as a bare minimum for an individual to avoid liability. They don't necessarily have to go above and beyond the standard of care to avoid liability, they just have to meet the standard of care. And a breach of the duty of care is represented as a falling below what this standard actually represents. If they fall below the standard, as I've just said, then they have breached their duty and could be liable in negligence. You then have to go on to the next step, which is, of course, trying to show that this breach, that this fall below the duty of care was the cause of the damage that is being claimed for by a claimant. So essentially then, what is the standard of care? Is it one that we can apply universally, or is it something that we have to apply on a factual basis on each individual case? And how is it measured? How do we measure what the standard of care actually is in a particular circumstance? Well, the courts were very, very keen to, at a very early stage in the development of this area of the law, suggest that the standard of care ought to be an objective test. It ought to be one that does not shift and change depending on the facts of a circumstance, or even the particular issue at hand, or even the person who is being accused of some kind of negligent action. So, since it's not up to the court to decide a specific standard for every possible circumstance, this would be unrealistic in the circumstances, the general approach is that the standard of care is the act of a reasonable person. So essentially, what would a reasonable person do in the circumstances if they had a duty of care to the claimant and the exact same things were to take place? If a reasonable person would have done what the defendant did, well, then that shows that the defendant has met the standard of care. If a reasonable person would have acted more and would have acted in a different way so as to try and avoid the damage being caused, even if they were successful or not, then this would suggest that the defendant has fallen below this objective standard and therefore may be liable for breach. The case of Blythe and Birmingham Waterworks from 1856 illustrates that a, quote, reasonable man and woman, but okay, this is 1856, don't forget, is the defined benchmark for which an individual is to be judged on the basis of the standard of care. It makes it an objective standard. What would a reasonable man or woman do in the circumstances, and if they would have done something differently, or maybe would have done more in the circumstances of this, maybe more of the same thing, then the defendant is likely to have fallen below this standard and is likely to have breached the standard of care. It is specified that the reasonable person doesn't describe an actual man or a woman. It is not what this specific person would do. They essentially, when we talk about a reasonable man test or a reasonable person test, we essentially are suggesting that there is a hypothetical individual who has the most basic standard of temperament. They are neither too cautious, nor are they too risk-taking. And the point of this, the point in that particular passage, is to suggest that because they are neither too cautious or too risk-taking, you're not subjecting an individual to too harsh a standard. If the reasonable person was too cautious, then the standard of care would be too high, and so essentially most people wouldn't be able to meet it, because most people wouldn't be as cautious as this hypothetically cautious reasonable person. If the standard of care was of a reasonable person who was too risk-taking, well then surely the standard of care would be too low and everybody would fall inside it, and then nobody would be able to find liability in the case of breach. So essentially, a reasonable person is just a very standard, bog-standard individual who is neither too cautious nor too risk-taking. In 1943, we get the case of Glasgow Corporation and Muir, who essentially is a case in which the defendant had been working in a tea room, and they had accidentally spilt a pot of tea onto a group of children, and this, of course, would have caused some injury owing to the temperature, scalding some of the children in the process. Now, the court was invited to examine what the standard of care would have been in this scenario, and whether or not the defendant had therefore gone above or beyond that standard of care, above or below, should I say, resulting in the spillage itself. Now, the reasonable person test, as established in the previous case, was applied objectively, and so where it was held, essentially that a reasonable person, acting in the circumstances that the defendant had been acting in, would not have reasonably foreseen that the accident could have happened or would have likely have happened, and so as a result of which would not have reasonably foreseen that there would have been a cause of injury. It was seen to be the case that a reasonable person, in this example, a reasonable person acting in this scenario would not have done anything really any different to the defendant, and so as a result of which they were not liable in the tort of negligence because they didn't fall below the standard. A reasonable person would have acted in a very similar way to the defendant in this case. In 1971, we get the case of Nettleship and Weston, and now this case is important because essentially what it does is it shoots down the idea that, for the most part, we should adjust the standard of care. We should adjust it on the basis of somebody's age, maybe somebody's temperament, or maybe some other factor. We will get to the application of the standard of care when it comes to children in a future lesson, because the standard of care does adjust, but only in certain circumstances, i.e. the age of the child has to be significantly lower than that of the age of majority, essentially. But the case of Nettleship and Weston talks about the idea of competence and the idea of the varying levels of competence and whether or not this could adjust the standard of care in these examples. So The courts have often been invited to adjust the reasonable person standard for different circumstances, and this case is an example of the courts being invited to do just that, but also being reluctant to do so as well. And we'll look at exceptions in the next lesson. So this was a case which involved a learner driver who had crashed into a tree, causing relatively minor injuries to the non-qualified driving instructor. So there were some injuries, but nothing was too serious. Now the question for the courts was whether or not the reasonable standard and the reasonable person test should be applied objectively. Would the courts approach it from the perspective of that of a learner driver, or would they suggest that the reasonable person is a reasonably competent driver? So should there be a different standard of care? Should the standard of care be applied, be the application of a reasonable person who is a learner driver, and so therefore be slightly lower, which would then probably have meant that the defendant would not have been in breach of said standard? Well, Lord Denning concluded that the standard of care in this case was that of an experienced, skilled, and careful driver. So applying an objective test and seeing that essentially the defendant had fallen below it. So the result was that they were liable for breach, or at least the issue of standard of care was not one that was going to be discussed in this case. And so as a result of which they were found liable in negligence. The non-qualified driving instructor also had some claims against them as well, or at least there was a reduction in the claims on the basis that they were a non-qualified driving instructor. But this case was very important in the sense that it showed that the adjusting of the reasonable person standard, up or down, essentially is one that is very reluctant, a reluctant choice on the basis of the courts. And so there will be exceptions in the next lesson to where this takes place, but for the most part, the courts are reluctant to adjust this reasonable person standard.